Hello and welcome to our Spotlight video series where we discuss cutting-edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, a firm that helps people who've been fired or afraid that they might be. I'm thrilled today to be joined by one of our superstar attorneys, Ivey Best. Welcome, Ivey.
Hi.
So what do we want to talk to folks about today?
One thing that I think I see a lot with clients is they don't know when it's okay to sign a document that their employer gives them or when it's not, or they're worried, if I sign this document that my employer's put in front of me, is that going to have adverse consequences for me in the future?
Yeah, no, I think we see that come up a lot in practice. So giving folks, when does it not matter so much? When kind of situations do you see come up that people are worried about signing that really it doesn't matter that much?
One thing that I see a lot is when someone's getting a disciplinary action at work, even like a performance improvement plan, we sometimes call that a PIP for short, or like a counseling, a write-up. And a lot of times at the end of a document like that, it will say, sign here to show that you received this. You acknowledge that you got this disciplinary action, this write-up, this warning. And sometimes I hear from clients, and I didn't sign, I refused to sign. And the reason that they don't want to sign it is because they don't agree with what's in it, right? They don't agree that their performance was poor. They don't think they deserve to get this disciplinary action. But the signature is not asking if they agree. It's not limiting their rights in any way. It's just showing I received the write-up. I see it. It was given to me. And in that circumstance, I would say there's nothing wrong with signing that. You're just acknowledging that you got it.
No, absolutely. And it's understandable that it's confusing to people because a lot of what, happens in employment law, it's not, but it feels like criminal law, right? It feels like you've been called down to the police station. It feels like you got the lights on you. And, they're and of course, in the criminal context, you don't say anything, right? Like that's the advice you get from your lawyer is, keep your mouth shut and ask for your lawyer. And I get why people sometimes employment law feel like, or an employment situation feel like it's the same, and it's not. I think you're exactly right. Like just, particularly in cases where you want to stay in the job, and that's not always true. A lot of people we see, they get a write-up and they're like, I want to get out. It's not a place I want to stay. But some people want to stay in that job. Like you don't want to make it worse for yourself, even if they're wrong, right? Even if the PIP is wrong, and a lot of times they are, and the details are wrong, and the bullet points are not accurate or whatever. If you then turn around and say, well, like I'm not going to sign this, and frankly, they could fire you in some circumstances. For most people won't for failing to do that. I get why that's difficult, but in most instances, like you say, like it doesn't prevent you from doing anything, from bringing any kind of legal action. Read the document. A lot of times it will say, I acknowledge receipt of this document. Fine, no problem signing that.
Right. And I think that's a good point you bring up, Tom, about your goal. If your goal is to keep working there peaceably, it may be in your best interest to sign that and try to work through it, right? Try to work on whatever's in the PIP, try to make the best of it, even though it's not the best situation. If that's your goal, it may be in your best interest to sign. If your goal is to leave, file a lawsuit, if your goal is to, make a stink about this bad conduct, then, if you want to refuse to sign, or sometimes I see people, they sign, but then they write a little note that says, I am only acknowledging receipt. I do not agree with what's in this PIP. And I don't have a problem with that. I mean, it may make your boss frustrated at you, so you can make that choice depending on what your goals are.
Yeah, no, absolutely. And that's right. Sometimes I'll tell people if they're really worried about it and the verbiage isn't already in the document, just write in parentheses under their name, acknowledge receipt only.
Right.
Yeah, this is not, and I get why people get confused, but this is not something that we see in our cases where, like in cross-examination, the attorney for your former employer says, aha, you signed this, didn't you? And therefore you agree you're a bad employee. We never see that in those cases. So I get why people are concerned about it. Particularly, they're frustrated. They've been wronged. The very people often who have wronged them are the ones who are shoving this document that they don't agree with down their throat. So it's a strategic decision again about whether or not you want to sign, how you want to play it. But it's a legal matter. It really doesn't matter. As we talked about earlier, there is one exception to that. Like, what do we see when it does matter what you sign and what you don't sign?
Yeah, the big one is a release, right? A release or a waiver, sometimes we call it. Something that says, I'm agreeing not to sue the company. I'm agreeing I'm not going to file a lawsuit. I'm agreeing I'm not going to take my employer to court. And typically we see like release or waiver language that says this is a release of claims. I'm waiving my rights. Those are the ones that you need to be careful about signing. Because if you sign a release or you sign a waiver, it's going to be impossible or extremely hard for you to say later, let's pretend like I didn't sign, right? It was a mistake. I didn't mean to. That's going to be really, really hard or impossible.
Yeah, absolutely. Those are the ones that we unfortunately see sometimes where people are like, I'd like to negotiate a better severance, and they've already signed the separation agreement. And again, exactly you said, except in rare circumstances, once you've signed it, it's a done deal. So you got to be careful of those. And I think most employers, if you're confused in the moment, I think most employers will be fine if you say, hey, look, I'm very emotional for me. Can I have a day to look at this? And then if you want to have a lawyer look at it, or if you just need a few moments, when you're not right in front of HR, kind of collect your wits and really read through it. Very few times is that going to cause you a problem with your employer. All right, Ivey, this has been great. I appreciate you talking about this very important topic, and I'll let you get back to the next thing on your desk.